The case is now being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, everyone. Welcome to the Appeals Court. I am Justice Rubin. I'm joined today by Justices Wolohojian and Sachs. We will be hearing one case this morning, number 2020-0039, Commonwealth versus JOYCE. We're hearing argument by teleconference due to the ongoing pandemic. The rules for argument, however, are the same as in our courtroom, which is to say 15 minutes per side with no rebuttal. We will hear first from Attorney Arter.
Thank you. Good morning. As you mentioned, my name is Corey Arter, and I represent Justin JOYCE. As you're aware, Your Honors, this case arises out of a motor vehicle stop in February of 2018. The defendants raised three main issues on appeal. Very briefly, one, that there's insufficient evidence as to intoxication or impairment. Two, that there was insufficient evidence that he was previously convicted of OUI in 2001, sufficient to support the third offense conviction. And three, and picking up on a question from the court, it's the position of the defendant that the retroactive application of the 2012 amendment to Chapter 9024(1)D it actually violates the prohibition against ex post facto laws, as at the time of the admission, continue without a finding was not considered a conviction and wouldn't trigger enhanced penalties under 24(1)D. Therefore, the application of the statute in 2018, making it a conviction for purposes of a subsequent offense, would violate the ex post facto laws. Very briefly, and I'll only touch on my first argument briefly and rely upon my memorandum for this argument. It's the position of the defendant that there was insufficient evidence of intoxication or impairment, or that his ability to safely operate his vehicle was impaired. As Your Honors know from reading the briefs, this is a situation where an officer parked in a parking lot outside of a bar that's letting people out, sees Mr. JOYCE pull out, admittedly sees another car pull in front of him. He's able to avoid an accident, so there's no accident. Decides he's going to follow the vehicle, follows it for some period of time around winding back roads in Marshfield, doesn't see him driving erratically, doesn't see him speeding, no accident, no other indicia other than that his wheels go over the fog lines at some point on what Donahue describes as an arguably windy back road. Field sobriety tests, it's arguable Mr. JOYCE says to the officer that he has an ankle injury, has arthritis, he has trouble standing on the one foot. He chooses between the lesser of two evils, does the straight line test, does it fine on the way down, on the way back when he's crossing over.
I'm sorry to interrupt you. For these purposes, or for at least for this argument, we view the facts in the light most favorable to the Commonwealth. And frankly, you're reciting them not really in that light. And so let's for the moment accept those facts in the light most favorable to the Commonwealth. Could you tell me which case is most analogous in your view on the facts themselves, where we held that the evidence presented here was insufficient?
Well, I would draw the court's attention to this line of cases I've cited in my memorandum, Rarick, Saulney, Arredondo, Soto, wherein while lay opinion testimony or observations after the stop are generally supplemented by a quantum of evidence, some other evidence, something that tips the scales in favor of a finding of impaired ability to operate a motor vehicle. My position on that would be that in this case, there's just a scintilla of evidence, a minor part, follows him, doesn't view any inability to safely operate his vehicle in according to what I can see from the.
There were bloodshot eyes. There was an odor of alcohol. There was garbled speech. He didn't perform the field sobriety tests well. There was, however you want to characterize it, some form of deficient operation of the car. Why don't we, I'm looking for a case where with similar facts, we held that the evidence was nonetheless insufficient.
Your Honor, again, and I did cite several cases in the memorandum, and I would just point out with regard to your characterization of the speech, my understanding is that he was speaking heavy. He said he was talking heavy. Mr. Joyce did testify that he did have some sort of a head injury, did admit he had 3 beers over the period of several hours. It's not, the odor of alcohol in and of itself is not enough. I would suggest that just the sheer quantum of evidence here is far less than the majority of the cases. And I do understand that officers are permitted to testify regarding lay observations of the eyes and the speech. In this case, he says he's fully cooperative, responds to all of the commands, was pleasant, was cooperative, did everything that was asked, didn't have any difficulty standing. The only time he had difficulty was crossing over after completing the 9-step test. My suggestion on that element, or this portion of my argument, is that I just think the quantum of evidence as compared to the majority of the cases cited in my memorandum is far left. That there wasn't that something extra besides just the observations or the odor or the eyes that would push it over the top. I will rely, at least for purposes of that issue, on my memorandum for that. I would like to move on to the remaining 2 arguments, which I think are important, and address actually an issue that this court asked the parties to supplement, which is whether or not there was sufficient evidence that the 2001, I apologize, the 2001 conviction, or the 2001 case resulted in a conviction for purposes of a subsequent offense. When posting the question to the parties, the court correctly pointed out that the 2012 amendment to the statute does indeed say that for purposes of 1D, a person shall be deemed to have been convicted if he admits to sufficient findings. However, whereas here the court is relying upon a docket from a case that predates the amendments to the statute, the courts, Valaton, Coney, Murphy, have held that if the record is not clear on its face that there was a conviction or a guilty finding, that it's either got to be a conviction or evidence of admission to an alcohol treatment program.
But doesn't the docket sheet, and I'm looking at page 11 of the record appendix, in the box for sentence or other disposition have or in the area for that, have the top box checked, which says sufficient facts found, but continued without a finding. And at the left, under disposition method, the box is checked for guilty plea or admission to sufficient facts. So it seems like we've got the docket sheet clearly indicating there was an admission to sufficient facts and sufficient facts found.
Your Honor, I would just again go back. The box does indicate that's an admission to sufficient facts. So this is a classic continue without a finding under the statute. My issue with this docket, as opposed to other dockets that clearly indicate that there was some sort of a order that there's an alcohol treatment program, if you look at the statute as it exists in 2001, it's evidence of a conviction, a guilty, or evidence that they were ordered to attend an alcohol.
Sure, as it existed in 2001. Right, but if, other than your ex post facto argument as to the statute, do you see a reason why this statute, the 2012 amendment, as applied to this 2001 docket sheet, doesn't make the 2001 charge a conviction?
Well, yes, I mean, I think it's part and parcel of the ex post facto argument, because if you go by Coney, Murphy, Valaton cases, you've got to show either conviction or admission to an alcohol treatment program, which is not indicated on there. There is an
Right, and those
indication of
were all
conviction.
prior to the 2012 amendment, correct?
Then you look at the 2012 amendment, and if you, and I had frankly not briefed it originally in my memorandum, but in looking in great detail at my sister's memorandum and the case law, it appears to me that this is a classic example of an ex post facto law, in that if at the time Mr. Joyce admitted to sufficient facts in 2001, what he was admitting to would not have triggered the 24(1)(d), or it would not have been enough to prove a subsequent offense. So let's say, for the sake of argument, he's in court, they continue the case without a finding. He's not ordered to attend an alcohol treatment program. At the time that he is admitting to sufficient facts, in his mind, and perhaps by advice of counsel, or at least in the law as it existed in 2001, that would not be considered a conviction for purposes of a subsequent offense. So if then in 2018, you take the amended statute and you apply it back to the case, at the time that he admitted to sufficient facts, it would not have been a conviction. It would not have triggered the enhanced penalties.
Let me ask you this, and I'll ask your sister the same question, although the opposite of it. Clearly, the event that triggered the conduct that rendered, or part of the conduct that rendered the defendant guilty in this case, assuming sufficiency and so on, took place after the amendment. That is the actual, well, I don't want to say that. Many elements of the offense were committed afterwards. But a static characteristic of his from the past, having been, having admitted sufficient facts, now leads to this situation when it wouldn't have at the time of the admitted to sufficient facts. And I don't think that this is a punishment for the admission to sufficient facts, but I do think an element of the offense for which he was convicted, an element of it took place prior to the enactment of the law. So my question is this: what is your best case for the proposition that a static fact about someone can't be an element of an offense, can't be made an element of an offense, and the person subsequently convicted of that offense, in part in reliance on the static fact from the past? And just to give an example, let's say a law were changed that said, it would be a lot like this, I think. Previously convicted felons may not work in a marijuana dispensary. They make a new law, now marijuana is legal. We don't know what the regime will be. And they say, well, it's going to be legal to work there, but not if you're a convicted felon. And the person goes and works there and is arrested. It's a misdemeanor and they're fined $100. And they say, but the conviction of the felony was before you adopted this criminal law. Is that an ex post facto law? And what's your best case for why this is?
Again, that goes back to my last argument and the argument about the sort of Cueva, Coney, Murphy line of cases, in that it goes to his state of mind at the time that he's pleading out. It's not like the example you gave where he was convicted. It was a conviction. At the time that it occurred, it was a conviction.
Yes,
at the time that
it didn't trigger, just like yours was an admission, but it didn't trigger criminal liability when coupled with other conduct until later. Same as this.
Except
the person who was convicted of the felony, maybe they pled guilty to the felony. At the time, it never, no one ever said to them, by the way, if marijuana becomes legal, and we set up dispensaries, you will not be able to work in one. No one said that.
Well, I think that I think it's an opposite because, again, it's a felony. I know I'm convicted of a felony. I know that there's a part and parcel of all sorts of things that go with having a conviction of a felony on your record. In this case,
there's something new. They've added something ex post facto, and the something is everyone else can work in the dispensary, but you can't. You did something before. We didn't tell you when you pled guilty before to the felony, because I don't think this label business is the key, that we're using it as the definition of conviction. You may as well say someone who admits to sufficient facts, right? You're just talking about the verbiage that's used.
Oh, I don't believe so. And I know my time is running short. I'd like to answer this question. I don't believe so because at the example that you give, the marijuana dispensaries and everything that goes with them didn't exist at that time. At the time that JOYCE admitted to sufficient facts, 24(1)(d) did exist. And at the time it said something different. So he was entitled to rely upon the law as it existed.
Your time has expired, but just to draw the analogy, at the time someone was convicted of a felony then, they knew they would lose their right to possess a firearm because there's a federal law that prohibits felons from possessing a firearm. Okay, so there were laws about what would happen to you if you committed a felony, but there wasn't one about working in a dispensary, and now they've added it.
Okay, and again, just to differentiate, if I may, the dispensary didn't exist at that point. Let's say, at least to my knowledge, at the time that JOYCE did make an admission to sufficient facts, he did it with the knowledge that subsection of that same statute that did exist at the time did not consider what he was doing to be a prior offense for purposes of enhanced penalty under the statute. The statute was changed. The existing statute that he pled guilty to, the statute that was in effect when he committed the crime, was changed. It wasn't an additional circumstances. Times have changed. There's new things out there. The actual statute that he would have reviewed or read or been advised of by counsel at the time did not provide. And I think that if you're looking at it, that the sole purpose of that subsection of 24 is to impose enhanced penalties. And if at the time, taking everything into consideration, he made an informed decision that if I admit to sufficient facts in this case, it's going to go away, it's going to be dismissed, it's not going to count as a prior offense for purposes of enhanced penalties in the future, because that's not what the statute says. If then the language of the statute changes.
I get your answer. Justice Wolohojian has a question. Even though
I may ask a question.
Sure.
My question is, if I accepted your argument, it seems to me that the proper relief is not to vacate the current conviction, which is on new facts, but to seek to withdraw the plea on the earlier conviction. Why would that not be the case? Because what you're really sounding to me as though you're arguing is that he didn't make a knowing plea because he somehow was relying on the state of the law at the time.
Because he wasn't clairvoyant.
Yeah.
I don't believe, and perhaps I didn't follow it to its logical conclusion, but I don't believe that's what I'm saying. What I'm saying is that you cannot now impose a different penalty that he was not exposed to or was not in effect at the time.
But
so the relief,
the difficulty there for you, I think, is that perhaps he did commit a new offense, and the sentence is being attached on this new offense, not on that previous offense. Anyway, so, I know your time is up, but.
And if I could just very briefly, because it's an interesting point, my argument would be, and the relief would be that, therefore, in the bifurcated penalty portion of this phase, that portion alone, if you believe there's sufficient facts for the intoxication, should be vacated. The third offense should be vacated. It should be remanded for sentencing on a second offense, because at the time, and what he pled to at the time would not have triggered the third offense. And so it's the enhanced penalty that should be vacated, not his 2001 plea. Because at the time it was knowing, that's what the statute existed at the time.
Okay, thank you very much. Excellent argument. I think we understand it. We'll hear it now from you, Attorney Anderson.
Good morning, Your Honors. Audrey Anderson for the Commonwealth. It pleases the court. The defendant's motion for a required finding of not guilty was properly denied on the charge of operating under the influence of alcohol, when the evidence viewed in the light most favorable to the Commonwealth was sufficient to prove that the defendant operated a motor vehicle while under the influence of alcohol, and his capacity to operate a motor vehicle was impaired. Officer Donahue observed the defendant almost slam into the back of a stopped car with his turn signal on. The car was stopped and the defendant almost slammed into the back of it. That's what caught his attention. He followed the defendant. The defendant was straddling the yellow lines almost into the middle of the road. He also was driving over the fog line where the officer thought that he was going to go off of the road. The defendant, once he was stopped, he could not produce his registration. The officer had to ask him 3 times for his registration because his speech was garbled and thick. His eyes were glassy and there was an odor of alcohol in the car. The defendant agreed to perform field sobriety tests. He failed 2 out of the 3 tests. The officer had to stop one of the tests because he feared for the defendant's safety. The defendant admitted to drinking, and the jury could consider this fact in its deliberations. The officer it was fine for him to say that, in his opinion, the defendant was under the alcohol. The judge told the jury that they could either accept or reject any opinion about the defendant's sobriety. It was up to them alone to decide. He also told them the same thing about the test, the field sobriety test. Are there any questions on that issues? Okay. Okay, the Commonwealth.
I'd like to start on the ex post facto issue with a question for you. You cite in your supplemental memo the cases of Corbett and Murphy for the proposition that this 2012 amendment did not have ex post facto effect. The defendant says that the statutes, at least as applied in Commonwealth versus Corbett and in Murphy, attached new consequences to prior convictions if the defendant was subsequently convicted of a driving under offense. Whereas in this case, the statute seeks to attach new consequences to an admission to sufficient facts if the defendant is subsequently convicted again. Does that make a difference?
Well, from what I understand, it is the punishment phase for the third conviction, not for the other two. It involves the third conviction. And I wanted to say something that there seems to be something where my sister's saying that the defendant, there's nothing that the judge could see that the defendant was sent to a treatment program. The docket clearly states that the defendant admitted sufficient facts. The case was continued without a finding under Chapter 90, Section 24D. The RMV records clearly state that the court has assigned the defendant to an alcohol program. That was on the 2000.
You have the record page for that?
Record page. Okay, give me 1 second, Your Honor. It's in,
Was that, I mean, I guess we can find it, but it was,
I know I have it right here.
that was admitted during the sentencing phase?
Okay, okay, I guess I'm lost. I was talking about the RMV records.
Yep, that, the RMV records, so mine.
The IMV records are in the defendant's record appendix at RA 49.
Okay, thank you.
And there are in other places, and I have them in my brief. So I really don't understand how it said that the defendant was not sentenced to an alcohol treatment program. And the enhanced punishment is imposed for a subsequent violation. It's not retroactive punishment.
Can I ask you this? Is it merely an enhanced punishment? Or is this a different crime? What there's this bifurcated trial, right? Yes. Is this an enhanced sentence, or the elements have to be proven beyond a reasonable doubt?
The elements did have to be proven beyond a reasonable doubt. The elements of the other convictions, Your Honor, is that what you're saying?
Yes.
Yes.
All right, so now if one of those, if we conclude that the only one of those that really holds up here is the admission to sufficient facts, the quaff, from whatever year it was. And that's an element of the offense. But that element was done prior to the adoption of this law that makes it an element of the offense. Why isn't that different from Murphy and Corbett, which are cases about punishment? And let me just add, I'm just looking at the case now. I know this is in a way dictum, but in Murphy, the court says the prior offense is not part of the crime charged. It relates only to punishment.
I think Murphy says that. Valentin may say that.
So is it, can we rely on that quaff, or we can't, because it would be ex post facto, because that element of the offense was committed before the adoption of this criminal law?
Well, I think you have to look at the new law, the broader definition, the later statute that applies, because the intent and purpose of the change is to increase the punishment by the subsequent offense and to include as a predicate the prior admissions.
Yes, but it changes the elements of the offense. It means that now you can be convicted where one of this third, whatever is subsequent offense crime, now you can be convicted of that for an admission, not just for a conviction. Whatever you can call it, however you want, definition, but it changes what the substance of the element is. And now one of the elements you're using to prove this crime, or not to prove, to constitute this crime, is an element that happened, an element for which the defendant is responsible, conduct of the defendant, prior to the adoption of that law. I'm not saying exactly what your sister said. I'm not saying this is ex post facto punishment for the prior, maybe it is, but for the prior admission. I'm just saying, how can an element of the offense have been committed? I understand that the offense wasn't complete until the defendant drove drunk again, but the, oh gosh, hard to believe. I apologize for that. And it's interfered with my train of thought. The part of the offense was committed prior to it being an element of the crime. Does what I'm saying make sense?
I'm a little confused.
Okay, so
I'm
I'm
sorry.
saying that, all right, let's just make it a cleaner hypothetical, although it's the same thing.
Oh, boy.
Let's say if there used to be a law that said
Mhm.
3 prior convictions and drunk driving, and that subsequent offense, and you're guilty of that. And now the law says 3 prior convictions or admissions to sufficient facts and a new drunk driving, and you're convicted. How can you use conduct prior to the adoption of that new criminal law, in this case, the conduct of admitting to sufficient facts? How can you use that to convict someone afterwards?
Even
Not
if
to
the,
enhance the punishment, but to create a new crime.
even if this new law is prospective and it's only concerned with the punishment for your new crime?
Well, it's only half new. Half of the crime occurred after the thing, that's the drunk driving. And part of the crime, having previously admitted sufficient facts, happened before the adoption of the law. You need both to convict, right?
Could you say that again one more time? I'm thinking. I'm trying to think.
The defendant here, you needed both a new drunk driving violation and a prior drunk driving admission, let's say, right? You need both of those, or there's no subsequent offense, right?
No, there's the first one, there's a drunk driving, admission to sufficient facts with the alcohol program. The second one, guilty, alcohol program. The third one, there's case law that says you don't need another conviction. But I guess I guess I don't know how to answer the question.
I think that the premise of my question is that we need this admission of sufficient facts. If we conclude that we need the admission of sufficient facts to count as the third conviction, right? If that's what we conclude, isn't that what we asked you to brief?
Yes.
All right. So
And I thought I had done that, but I guess I didn't do it.
I'm asking you the cases you cite, Murphy and Corbett, are both about increasing the punishment. This is about changing the elements of the subsequent offense crime. Why isn't that different?
I don't have a good answer for that, Your Honor. I'm sorry.
Okay, that's okay. I appreciate that.
When a person is convicted of operating under the influence and it's a subsequent offense, is a single conviction entered, or is it 2 convictions, one on the OUI and one on the subsequent offense piece? I'm asking as a general matter of practice.
If they've committed one, are you saying if they've committed one offense?
No, I'm saying if a person is convicted of operating under the influence as a subsequent offense.
Okay.
Are there 2 convictions entered, one on the OUI and then one on the subsequent offense? Or is that a single conviction?
I believe that's a single conviction.
Okay, so even if it's bifurcated at trial, which it always is supposed to be. So you have the first part of the trial. It's not really 2 trials, it's a bifurcated trial. It's 2 parts to the same trial. You have the first part of the bifurcated trial is on the current episode of operating under the influence. And then you have the second bifurcated portion, which is on essentially the defendant's criminal history.
Yes.
But nonetheless, at the end of those 2, only a single conviction results. Is that correct?
I believe the single conviction for the second, third, whatever it is the result of that. I can't say 100% positive because I'm not a trial attorney.
You don't have an order of conviction, a judgment of conviction on the jury trial. At the end of the jury trial, no judgment of conviction enters until after the second part of the bifurcated trial. I mean, we can probably look in the record here. I just don't know.
I may be incorrect, but I don't think so. Because you have the trial on the third, jury doesn't know it's the third. Then you have the bifurcated trial. Then the judge enters a judgment on the, say, third OUI. And then the punishment. I believe that's it.
Okay, now I've confused you for some of your time, so although it's expired, I don't know if there's anything else you want to tell us. I'll give you another few moments, or if there are questions.
I think we've probably covered everything. Unless your honors have any questions, the Commonwealth rests on its brief.
All right. Thank you very, very much, both of you. Very surprisingly